if we want to keep going on this, I was going to turn to the merits, but can you address McCutcheon squarely? Because that's obviously been the emphasis on the other side, is that McCutcheon changed the landscape from Colorado Republican.
Sure. I don't think McCutcheon changed it at all. In fact, McCutcheon expressly relied on this provision as a basis to reach the holding in McCutcheon. And I think what this highlights is what's really going on here. And we heard it in, Justice Kavanaugh, your questions, your colloquy with Mr. Francisco. They are setting up bait and switch 2.0. Bait and switch 1.0 was McCutcheon. They came in and said to McCutcheon, hey, we need to get rid of these aggregate limits. Why? Because we got all these other protections. Look, coordinated expenditures are limited too. And then you said, okay, well, fine, we'll do that. And you put it in your opinion that coordinated expenditures was going to protect us. Now they're coming back and saying, just kidding. Actually, the coordinated expenditure provision is unlawful as well. And why do you not need to worry? Well, we've got these other limits. But then you ask them, Justice Kavanaugh, you say, well, do you think those other limits are constitutional? And they say, well, we're not so sure. We're not going to take a position.
Well, they did say the bribery laws,
right,
the disclosure laws.
Those are the two.
And I think earmarking, although that was a little questionable. But I think those three were the three that said.
I heard two. I heard bribery and disclosure. And I think that gives away the game. Because what's really going on here.
Assume it's three. So assume it's bribery, disclosure, and earmarking. Why is that not enough?
So bribery, disclosure, and earmarking, you know what that leaves out? All of the other 50 pages of laws in FICA, which you have considered over 50 years. You've upheld them, decision after decision after decision. And I think what Mr. Francisco's position is, and I think I'm glad he laid it out, this wolf comes as a wolf. He has basically told you that they're going to keep litigating to knock down every single one of the restrictions. And that includes the limits on donors to candidates directly. But just listen to how the donor candidate limit is going to be undermined by this.
I didn't hear that.
Well, he said that the only two prophylaxes you need are bribery and disclosure and maybe earmarks.
Well, donors, I mean, we were talking about parties.
But here's how you get to the same place, Justice Kavanaugh. If you rule for them here, okay, what's going to happen, right now there are two limits that apply, the donor to party and then the party to candidate. So we're essentially going to get rid of the second one because coordinated expenditures are going to be unlimited. That limit goes away. Then you asked him, well, what about the first limit, donor to party? He said, oh, we're not taking a position, and wink, wink, he said, don't be blind to reality. The reality is they're going to be coming back and asking you to overturn that, and that the logic that they're asking you to embrace here is going to mean that that provision falls too. So what's that going to leave? It's going to leave the donor with the ability to give infinite money to the party, which the Solicitor General tells you is inextricably intertwined with the candidate, and then the party can make unlimited coordinated expenditures, which, by the way, aren't just about speech. It's paying the electric bill, it's paying the florist bill, it's paying the pizza bill, it's any expense that the campaign wants.
What about the idea that the parties are, I've said this multiple times, but the parties have been weakened overall, and this case is at least, I think Mr. Francisco said, starts to restore the strength of parties, although obviously it doesn't get them all the way there in competing with outside groups.
Look, I think if that were really their concern, what they could have done is file a very different type of challenge. And if the problem is, look, super PACs have too much ability, then what they should have done is—
Don't you think that's a real concern?
I think that if that were their real concern—
Do you think that's a real concern? The parties are very much weakened and disadvantaged compared to the outside groups. At least that's
I think the answer to that concern is to say that parties should be able to get unlimited contributions, but only so long as that money is used for their independent expenditures that were blessed in Colorado 1. I think that's a solution that's rational, that's consistent with the general framework, with the distinction between expenditures and contribution limits, and that doesn't require unrolling and unraveling 50 years of campaign finance law. That's not what they asked for. And they didn't ask for it for a reason, because what they're really aiming at is all the other laws that they want to take down. This is like the camel's nose under the tent. If you agree with them in this case, you're going to get petition after petition coming to you for this provision and that provision, and overrule this precedent and that precedent. You're going to be deluged with petitions, the dominoes are going to fall, and you're going to have to reconstruct campaign finance law from the ground up. I have a better solution for you. Don't go down this path. We have a doctrine, you have a doctrine, stare decisis. The whole purpose of the doctrine is to preserve the rule of law, to preserve the appearance and fact of the integrity of the judicial process. And it says you don't just throw out one decision when maybe you're having second thoughts about it later, especially when it's going to mess up a whole broad area of law. So you can apply stare decisis if you get there.
I appreciate your solicitude.